Mr. Perkins. Awful. I'm for this. Ms. Goldborough, I'm getting ready to. Good afternoon.
DCRD in and for Duval County in the state of Florida is now in session. The Honorable Judge Mark Morello presiding. Ensure all cell phones are completely powered off and are not visible. No talking while court is in session. You may be seated. Thank you.
We don't need to be on the record yet. Mr. Mizrahi, did you give me an amended opening instruction? I think I can just read what you gave me, but
Sure, it's on the screen.
my screen's not on. Is yours on?
I can email it to you. It's the same. It's just, looks better.
I don't know that we made any changes to the...
No, sir, I don't think we did.
We need to figure out why this screen's not working. Here this morning. Can you get IT here? No, it's... that humming noise. Are you calling about that? I need to... No, that's fine. I think I'm just going to read from here, so... Karen, you ready? You say you are? Yeah. Okay, let's go on the record. Show Mr. Tillis is present with his attorneys and the state here today for our penalty phase. We had our charge conference yesterday. One additional matter, Mr. Fletcher, Mr. Tillis had filed, I think right at the end of, just prior to commencing the guilt phase of the trial, another written Nelson petition. The allegations contained therein have all been previously adjudicated or heard by the court. I don't see any need to address any matters. It's probably moot at this point anyway, but I just want the record to show that the court did consider that most recent Nelson petition and am denying it. Okay, I know the parties had given the state and were kind enough to copy the court. I have the amended notice of intent to present mental health expert testimony and disclosure of statutory and non-statutory mental mitigating circumstances. The state, I think it indicated in the email, they may have an objection to some of those. I reviewed them. Frankly, the court did not really necessarily have any issues with any of them, but Mr. Mizrahi.
I just assume be heard before we charge the jury, just to see, because I'm not sure exactly how the evidence is going to be presented. But
Well, I mean, that's obviously fair, so.
some of the ones that are factually based, it'll depend on what comes out. The ones at the end, that Mr. Tillis is a human being, that the jury can consider mercy, I don't think are mitigators. And I understand everything can be a mitigator, but these are, I don't think they should be listed and instructed by the court. But ultimately, I probably concede that they can all be read.
Okay,
I
all
just
right, well,
wanted to-
we'll address them.
Yeah.
Ms. Miller, I think he's right. I don't think we need to necessarily address them now, but. Right, given the schedule as the parties have outlined it, let's touch base again on these issues tonight before we leave.
It would be easy if the list of mitigators also came with it, the yes, no, like in the verdict format. Otherwise, we're going to have to go back in and type in. Oh, yeah, so you're not going to, okay, very good, whatever. Okay.
Care who does it, so.
All right, that's fine. I was just, anyway. Your Honor, we have some evidence that we can go over while we're waiting for IT.
Yeah, before you do that, let me, Patrick, I know you're working on that humming noise, but also this screen is not working. Yeah, okay, thank you. Mr. Mizrahi, go ahead.
Yes, sir. We have three pieces of evidence. I think they've all been talked about yesterday. I have listed them as states L, 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 5L, 5M, and 5N. The reason for that is 5K and 5L were, 5J and 5K were not introduced in the guilt phase, and they're not going to be introduced in the penalty phase. So I've labeled 5L, 5M, and 5N. And I believe Madam Clerk will introduce those pursuant to prior defense objections, mind you, as 114, 115, and 116.
Well, I think the photograph objection, I believe, was taken care of. The state had stipulated that they would cover up the writing on the shirt.
Correct, we did that. I think they were objecting to the photo in total, in addition to
Still
the...
objecting to it? Yes. Okay, all right. Well, that's fine, of course. But the state, just for the record, the state did take off the writing.
We did, yeah. That's correct. May I have a moment to confer with counsel, though, before I address them? We're good, Your Honor. No, sir. Yeah, the court asked the parties to remind the court about the inquiry as to the alternates and the regular jurors about, yeah. I agree the rule is in vote, Your Honor. We're on the record. The rule is still in vote. We have allowed in the direct family members of the victim who have already testified, who are only going to provide victim impact into the courtroom. Our witnesses, with regard to factual information, the other prior convictions are outside, and they're not in the courtroom. Experts are allowed to.
We have a couple of our experts.
No, I think experts are allowed to do that.
Ms. Miller, you can make favor testing or say something.
Testing? Testing? Testing?
Mine works.
Hello? Is it supposed to be blue or not blue?
Blue.
It's blue.
You're an attorney.
I'm fine with it being.
I think we're fine leaving it for right now. Obviously,
I was gonna say, I prefer this be off. And the Zoom witnesses, I don't intend for them to testify until tomorrow morning.
you don't need to Zoom today?
I believe all of our witnesses are live today unless we move at an exceptionally brisk pace. Those are the two, the one is the school teacher in California, and then Mr. Tillis' son, who's in Vancouver, that we intended for both of them to appear via Zoom first thing tomorrow morning. The only reason we would get to him tonight is if we moved way faster than I anticipated.
Okay, so I do have my screen working. So, Mr. Mizrahi, what's on the screen is I can read off the screen, in other words.
Yeah, well, I'm 99.9% sure all we did was change the formatting.
Right. Okay, are we ready for the jury to come out?
State's ready.
Okay, let's bring them out. Track of how many spectators we have. Remember, 16 is our limit, so I think we're pretty close to that right now, so. Hmm? Yeah, just 16 total is all we're allowing back there, so I think we're good, but just, we might be right at 16. 19? Yeah, nobody else coming in. Like, everybody that's in here seems to be essential, so. And everybody looks pretty spread out, so.
Except for the front row, they want to be together.
Well, no, they got to be spread out a little more. I just noticed that. Guys, that's the rule.
I might have an extra one, let me just.
Detective Sullivan, you may need to move to a different row.
Third row, yeah.
We have a empty chair table there.
Yeah, I don't mind if you want somebody to sit there, that's fine.
I'd like to solve that first.
No, I can't have victims out in the well. That's fine.
The jury is entering the courtroom.
Okay. Okay, thank you. You may be seated. And members of the jury, welcome back. Appreciate everybody being back today and in a timely fashion. I apologize for keeping you back there a little bit longer than I would have liked. Once again, we started our morning calendar, cases unrelated to this case, at 8:30. That ran a little bit longer than I expected and than I would have liked. So that's my fault, nobody else's, so don't blame anybody else for the delay. But we are ready to proceed today. Before we proceed any further, I have no doubts whatsoever that all of you have followed the court's instructions between the end of the guilt phase last Friday night, and today for our penalty phase as to not discuss the case with anyone. So I'm going to ask, or to review any media coverage. So I'm going to ask you a couple questions this morning related to that. If any of you violated the rule in terms of discussing the case with anyone, I need you to tell me now. So if anyone did that, please raise your hand. Very good. I don't show any hands. And of course, the case has received media attention, as I'm sure you're aware. Has anyone viewed any, either intentionally or inadvertently, any media coverage between Friday evening when you left here and Wednesday morning when you came to the courthouse? If you saw any media coverage, please raise your hand. Very good. I don't show any hands. State ready to proceed?
Yes, Your Honor, we're ready.
Defense ready to proceed? Members of the jury, you have found the defendant guilty of one count of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of the trial, is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proven beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, 3, whether mitigating circumstances are proven by the greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument of counsel, you will be instructed by me on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, excuse me, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. And again, members of the jury, I will have the final instructions for you for this phase of the trial at the conclusion of the presentation of the evidence and closing arguments that will be given by the attorneys at that time. We will now proceed to opening statements, first from the state. Mr. Mizrahi.
May it please the court.
Yes, sir.
Counsel? Ladies and gentlemen of the jury, this defendant's evil acts were publicly denounced by your just verdicts last week. Your verdicts confirmed the horror that this defendant inflicted upon Joni Gunter, and your verdicts confirm that this defendant was guilty of first-degree premeditated murder and first-degree felony murder. But as you already know, from the evidence that you received last week, that this case is the very definition of an aggravated murder. This was an aggravated murder because you have already found, beyond to the exclusion of every reasonable doubt, that Joni Gunter was kidnapped during the process of this homicide. During the process of this murder, she endured a separate horror of being confined against her will, being kidnapped. This was an aggravated murder because, as you heard, the motive behind this murder was the elimination of a witness, Joni Gunter, so that the defendant and his brother would not face criminal penalties for their confinement. You know this was an aggravated murder because the murder, in the way it was implemented, was shockingly evil, was heinous, atrocious, and cruel. You know that this was an aggravated murder because this shockingly evil crime was debated and discussed. And it was not implemented in a moment of premeditation, but after careful deliberation about who was going to inflict the deadly blows. These evidence of 4 aggravating factors were presented at the trial, the guilt phase of the trial. You have already heard all of the evidence surrounding those 4 aggravators. The crime was done during the commission of a felony, specifically kidnapping. The motive behind the crime was the elimination of a witness to avoid lawful arrest. The nature of the crime was especially heinous, atrocious, and cruel. And there was a heightened premeditation, a cold, calculated, and premeditated, without legal justification, 4 incredibly weighty, powerful aggravators. Heinous, atrocious, and cruel, and cold, calculated, and premeditated, in this case, demonstrate that the defendant is worthy of the death penalty, as does the kidnapping and the elimination of a witness. But the heinous, atrocious, and cruel is you heard about the number of breaks to Joni Gunter's skull. 5 at a minimum, maybe even 7. It was hard to tell whether the breaks were related to each other. But that's not all you heard. You heard the very detailed discussion about the 4 other breaks to Joni Gunter's nose and the 3 to her left hand. You heard how Dr. Bucksbaum and Dr. Walsh-Haney described those as abusive injuries, as tearing the bone, as twisting the bone and creating a spiral fracture, and as impact. And that those would have occurred during life, before unconsciousness. That is the pitiless nature in which this defendant killed Joni Gunter. And that is especially heinous, atrocious, and cruel. We discussed in jury selection the concept of cold, calculated, and premeditated versus just regular premeditation. We use the examples of markers or Clorox wipes. And the looking at it, the making of the decision, the reflection upon it, and the doing of it can be formed in an instant. But when you debate, it's no longer to be formed in an instant. That is the definition of heightened premeditation. It makes it cold, calculated, and premeditated. And you can tell by the nature of the injuries inflicted, the torture that Joni Gunter endured, and the amount of time necessary would have done to inflict all of those injuries, combined with the debate that happened before. 4 weighty aggravators that the state submits are more than enough to impose a death sentence in this case. But today, you're going to really learn about the person that this defendant is. We are going to do a deep dive into the character of this defendant. What happened to Joni Gunter was not an isolated incident. What happened to Joni Gunter wasn't this defendant's worst day. It was his everyday. You will learn here in just a few moments about how this defendant in 1989, before cell phones were prominent in our world, that this defendant kidnapped and tried to rape a completely innocent woman whose only crime was her car broke down on Interstate 75, going to visit her mother. And because no cell phones existed, she was relying upon the kindness of strangers to help her at night, stranded on Interstate 75. And after she had waited for a significant period of time, one person drove up. A stranger, but kindness was not in his heart. It was this defendant. And Maria Leone said, "Sir, can you please call for help? I just joined AAA. They can send a tow truck and help me, but I have no way to call, and I don't know where the phone is." This part of Interstate 75 was between Sarasota and Tampa. Not 275, but 75. It's a very rural area, especially at that time. There's not a lot around, and it's pitch black. "Can you make a phone call?" was the request. "No, ma'am. You're going to have to get in this truck if you want some help." Young Maria Leone, a young adult at this time, made what turned out to be the worst decision of her life. Because she got into that defendant's truck. As soon as the door closed and he pulled off, she knew. Trying to make small talk. "Hey, where's the gas station? Where's the 7-Eleven? Is it at the next exit? Where are we going?" Silence. And she knew. Speeding down 75, they pull off on an exit and go back to a construction site. A construction site that this defendant actually happened to work at, and it's actually the way we ended up catching him. At this construction site, the defendant pulls pitch black, mind you. Not a soul in sight. Pulls out behind the back of this construction site. There's dirt everywhere, construction stuff. No one's around. And it begins. The strangulation almost leaves Maria Leone unconscious. She is scared that she will never, ever see the light of day again. The defendant grabs her breasts. It is very clear that the intent of this attack is not just violence, but sexual violence. And in this struggle for her life, this defendant was trying to rape her. And it was a miracle happened. Nothing else can explain the fact that men that were working that construction site were driving around to making sure the construction site was secure. And headlights just happened to appear before this defendant could finish what he had done, what he had started. See, there was a ditch right there, and in Maria Leone's mind, she thought, that's where I'm going to end up. But she didn't. When the headlights came, the defendant panicked, got off of Miss Leone, and she was able to get out of the truck. During this process, in her efforts to get out of the truck, the defendant kept locking the doors if she would unlock it. She didn't walk out of the car, she fell out of the car, out of the truck, onto the ground, and of course she's terrified of the people that are coming up. It just so happens that the defendant looked like a clean-cut guy at the time. The people that came up were giant men with large beards, and by the looks of it, she wasn't sure if they were going to be good guys as well. And as they come up to try to help this poor woman that has just fallen out of a truck, the defendant speeds off. And it just so happens that these men are the nicest men in the world. They totally take care of Miss Leone. They help her. They go fix her car. They get her up in a hotel because she's so frazzled, she doesn't want to continue the drive to her mother's. She's not sure if she should go home. She's calling friends. She doesn't know what to do. She ends up going home. Anyway, these construction guys had seen the defendant at that construction site because he worked there. And so they ended up finding his name. The defendant's picture was put into a photo spread, an array of photographs, and Miss Leone picked him out. They had caught him. And the defendant was convicted of kidnapping, all the way back from a crime in 1989. Your next deep dive into who this defendant is, we'll fast forward all the way to 2006. 1989 to 2006, a lot had changed in this world. But not this defendant. No, he was the same guy. This time, he was in Jacksonville. His target was not a broken down young woman on the side of Interstate 75, but a 14-year-old child. A 14-year-old child that made some silly decisions, nothing bad. Decisions like, instead of taking the bus to go home, I'm going to get off with my friend, and I'm going to hang out with her, even though I'm not really supposed to. I'm supposed to take the bus and go straight home. But I'm going to hang out with my friend. Then it turns out the friend isn't supposed to hang out with her, and it's all 14-year-old drama, and the friend isn't with her, and she's standing on the side of the road by herself, having gotten off of the bus and having no way home. The defendant sees it, pulls up. Hey, you need a ride? Little 14-year-old girl? By the way, he's in his mid-40s. Sure, she says. That'd be great. You just saved me. I was going to have to call my mom and get in trouble for not riding the bus home. Thank you for helping me. She knew as soon as she got into that truck that she was in trouble. This defendant slaps her so hard, strikes her face so hard, that 14-year-old Brescia Settle knew it was fight or flight. It was fight or submit. And she made the decision at that point, well, I'm going to try to get out of this alive. I'm going to pretend that as a 14-year-old, the defendant doesn't need to force me. He's already hitting me. He's already hit me. I'm scared I'm going to die. I don't know how I'm getting out of this truck. So I better pretend that this is not a problem. And she actually tells him, you don't need to do this. I may be 14, although she never says her age. Let's be clear about that. She says, I do this all the time. I'm cool. I'm a prostitute. If you pay me, we'll do whatever you want. And boy, this defendant does whatever he wants. He has oral sex, penile vaginal intercourse, multiple times at multiple locations with this 14-year-old child. At one point, he ejaculates into a towel and throws that towel out of the window. Once he's done with the victim, he pays her $40, and she leaves. Maybe we can do this again sometime, little 14-year-old. The victim had the defendant drop her off near where the friend's father lived, because she knew where that was. She lived miles away. So she goes knocking on the door to her friend's father. Her friend is not home. She's crying, she's bawling. She says, "Help, I've been raped." And it all starts from there. It takes a couple days for the authorities to get involved because the child doesn't want to tell her mother. And her friend's father doesn't tell anyone. He just keeps the secret. But 2 days later, the child finally is convinced by other friends that she needs to tell. And she tells her mom. She actually goes to the Child Crisis Center and gets a medical exam done. Her first gynecological exam, by the way, is to examine what she looked like after the rape by this defendant. 14, in stirrups, she has to relive the horror of 2 days before. And the shame of it all. But she was smart enough that she remembered where this incident took place. She went back to the location where the defendant threw out the towel. She got the towel. And DNA confirmed the defendant's profile on that towel. Additionally, this 14-year-old child, having provided a sketch to police artists, which actually was strikingly similar to the defendant, it's pretty impressive. After that, she identifies him in a photo spread, just like Marie Leone had done in 1989. In 2006, she says, "That's the guy that hit me and forced me to have sex. Oh, by the way, she's 14, so it doesn't really matter if she consented or not." And that defendant was convicted of abusing a child and child abuse. That is the deep dive of the multiple decades of this defendant's character. We heard in jury selection over and over again, 30 times on Monday and 30 times on Tuesday, that death is never required. Not in this case, not in the worst possible imaginable case. And that is the state of the law. And you will not see the state of Florida bang on this table and say, "You must sentence that man to death." Because as a society, we trust your judgments. But each and every one here lawfully indicated that they could vote for death. Listen very, very carefully to the aggravators the state presents. And I submit we're going to be able to present all 5 of these aggravators. Mind you, the prior record is called prior violent felonies. You're going to find that those are violent felonies. And there's not just one of them, there's 2 of them. It counts as one aggravator, but the fact that there's 2 makes that aggravator even more weighty. And that aggravator, all by itself, the prior record, all by itself, is a weighty enough aggravator that you can vote for death. Now, I ask you to listen very carefully to the mitigation presentation in this case, if there is one. In many cases, it's not mitigation. Now, it's never aggravation, let's be clear about that. The only thing that's an aggravation are the statutory aggravators. But you'll listen to the mitigation, and you'll decide whether or not it reduces that man's responsibility, whether it mitigates the sentence, or whether it's just a fact of his life. Some good facts, some bad facts. Human beings go through trials and tribulations, both good and bad. And some of those things can reduce or mitigate the sentence. But I submit you will hear nothing that changes or reduces or weighs against these 5 weighty aggravating factors. Some mitigators can be very weighty. I submit not his. What happened on 3551 Bowden Circle East was shockingly evil, was heinous, atrocious, or cruel, and for complete justice, to hold this defendant fully accountable for the heinous murder of Joni Gunter, for his violent felony history that he's demonstrated from 1989 until now. We are confident that you will hold him fully accountable and that you will do what the facts in this case require. And that is to vote unanimously for a sentence of death. Thank you.
Thank you, Mr. Mizrahi. Mr. Maris? Yes, sir.
Yes, sir.
Russell Tillis is a damaged, badly broken individual, but not beyond redemption. Over the next several days, you will learn the details surrounding his upbringing in life. I agree with the state. We're going to take a deep dive. But all of you agreed, and the law requires that you examine more than what you just heard out of the state's mouth. All of you agreed to do that, so we're going to do that. That's the portion of the trial that we're in now. You are going to learn that Russell Tillis was poisoned by the violence that he witnessed, that he endured, both sexual and physical, and also the drugs that he used. You're going to hear from witnesses in his past. You're going to hear from his uncle, Roger Hartley, who Mr. Tillis took in during a hard time for Mr. Hartley. That is his mother's brother. You're going to hear from Timothy Pendergrass, a childhood neighbor who also witnessed the abuse by Mr. Tillis's father on his mother. You're going to hear from Timothy Pendergrass, who's going to tell you he personally observed it to the point that as a 11 or 12-year-old hopped over a fence and actually struck Claude Tillis, that's Russell Tillis's father, with a stick to stop the abuse. You're going to hear from Mr. Pendergrass that Mr. Tillis was willing to help him, was handy with tools, was handy with repairs, and was there for him when he needed him. You're also going to hear from a former wife of Mr. Tillis and their son. You're going to hear information about his past, about the details concerning his upbringing, the abuse that his father visited upon his mother, upon him, upon his brother, both physical and sexual. And then you're also going to hear from experts. You're going to hear from a prison expert, Ron McAndrew, who's going to talk to you about his review of Mr. Tillis, both of his existence incarcerated, and you're going to see records that reflect that he's not been in any trouble since he's been in custody. In this case, really since 2015, you're going to hear about the distinction between death row and general population from Mr. McAndrew. You're going to hear from Dr. Toomer, Jethro Toomer, who's going to talk to you and express his opinion about trauma. The things I just described, his existence, the deep dive the state wants to take. Let's include his childhood. Let's include the events that he saw, both verified by Mr. Tillis, but other individuals and other records. Dr. Toomer is going to talk to you about his opinion as to how that affects an individual. It doesn't reduce responsibility. That's not what we're talking about. The state suggests that. That's not what we're talking about. What we're talking about is we accept your verdict. There is no excuse. There's no justification. That's not what we're going to present to you. What we're going to present to you is how Mr. Tillis got to this point. What things happened to him. How did those things affect him? We've all had our own experiences. He is going to be someone that you learn about. You're also going to hear from Dr. Daniel Buffington, who is a pharmacologist, an individual trained and expert in drugs, in understanding the effects of drugs, in understanding how it changes the way we think, what we do. Trauma related to his abuse that he personally suffered, that his mother suffered, and the path of drugs that he took have damaged him. Damage not beyond hope, not beyond some possibility of redemption. We're at the point in the trial, and we talked about it both on Monday and Tuesday when you were selected as this jury, to determine what the appropriate sentence is. And it's true that each of you were asked and each of you agreed that death is never required. The state, I guess, wrote down how many times we asked each of you. It's a pretty serious question. It's a pretty serious case. And it's so serious that the law is that unlike the verdict as to guilt or innocence, at this stage, it's an individual moral decision. That's what the law is. That's what the court's going to tell you. That means each of you has to decide for yourselves. When you were deliberating as to the guilt and innocence, you had to come up with, right, unanimity. We all agree this or we can't render a verdict. That's not true in this case. And you all agreed and saw that distinction, at least in your answers to the questions during jury selection. And it's true that death is never required in this case, certainly. In any case, even the worst case, it's never required. What is required is that each of you consider both aggravation and mitigation. The court's going to tell you mitigation can come from anywhere. It can come from the case. It can come from what we present. It doesn't have to come from those two places. It can come from your sense of mercy. It can come from your decision that taking a life is not something I'm going to vote for. And when that decision is made, your deliberation is over. Now, we talked about in jury selection, you would respect and hope that others would respect your decision. I ask you to continue in that belief and act accordingly. We talk about things, but being able to do them may be a little bit more difficult. But in this setting, at this moment, it is your decision alone. It's always appropriate to vote for a life sentence, life without parole. Okay, what that means is that suit he's got on, he won't be wearing it again. He won't be wearing it again in his life. He will be wearing what the prison issues him. A sentence of life will reflect the seriousness of this crime, but it will also reflect the presence of mitigation in whatever form it comes in this presentation, and that's why we're here. As I said at the beginning of my opening, Mr. Tillis, I believe you will determine is damaged. He's badly broken, but he is not without redemption. Ron McAndrew will tell you he has skills. He has the ability to do good things if in prison for the rest of his life. And again, that would be the rest of his life. And we believe that the evidence supports a life sentence. Thank you.
Thank you, Mr. Mayor. Before proceeding further, I think you've already met Ms. Nancy Crawford, who'll be with us today and for the remainder of the proceedings, but I just wanted to make sure that you had been introduced to her. State, Ms. Wilson?
Yes, and our state was Maria.
Last name again, please?
Leon, Miss Leon.
Disclose that respond.
State calls Brescia settled.
Where do you want it? Ma'am? Through the middle.
It's okay.
Thank you, ma'am.
Sales associate,
And where do you live in Jackson? Just the part of town.
outside.
And who do you live there with?
My husband and my daughter.
What does your husband do for a living?
He's a construction worker.
How old's your daughter?
He's 1 year old.
Do you know a person by the name of Russell Tillis?
Yes.
How do you know this person?
That one dreadful night I experienced when I was 14 years old, that was the only time I ever saw him or came in contact with him.
You see him here in court.
Yes, I do. He's sitting right
Where
there,
he's seated and what he's wearing.
right there with the white mask, long hair, glasses.
And the record reflect the witnesses identified the defendant.
The record shall so reflect.
So, Ms. Settle, I want to turn your attention back to when you were 14 on March 27th of 2006.
Yes.
Can you begin by describing to the jury where you were going to school and how you ended up on the street confronted with Mr. Tillis? Just give us a little bit of the background.
Well, I went to Jeff Stewart Middle School, and my only friend there that I really spent a lot of time with, I wasn't supposed to hang out with because we got in some trouble before. My mom just didn't want me hanging out with her. Bad influence, that's what she felt like. But anyways, I usually take the bus home all the way to Collins Road. But this day, Monday it was, I decided to walk with April, is her name, to her house. And we ended up hanging out to go to another friend's house that lives on 103rd right across from Walmart. Her name was Nicolette, and she went to, she told me to stay by the bus stop right across the street from Walmart and wait for her while she goes and gets our friend Nicolette, but the mother doesn't like me, so that's why she didn't want me to go with her. So I,
It's kind of like
yeah,
18-year-old drama.
exactly. So I waited and waited and waited and then came,
Bill, can I stop you right there? I may approach the witness. I want to get the mask seems to be bothering her.
sorry,
It's okay.
it's fine.
Well, I don't want you to feel.
Yeah.
So you were going to meet Nicolette. Nicolette's mom doesn't like you. It was all convoluted. So what happened?
Right, so I waited and waited, and then I saw April and Nicolette walking towards me, and then I ended up seeing her mother with them. So I knew that I wasn't supposed to be seen, so I kind of hid myself a little bit in the bushes until they walked past me. And once they walked past me and crossed the street to Walmart, I saw April kind of turn around and point the finger and basically saying, wait for us. So I waited, and I got tired of waiting. I just wanted to go home. So that's when I was thinking in my mind, what am I going to do? I just want to go home. I don't want to be here anymore, you know. I got mad at April for leaving me behind and making me wait this long by myself. So I ended up, sorry, one more time. I ended up trying to figure out what to do, how to get home. So in that moment, I remember a truck stopping right there on the curb and was holding up traffic. And I remember the horns honking behind him, basically trying to hurry up. What are you doing stopping there? So
Are you standing on 103rd Street?
I'm standing on 103rd Street across from the Walmart by the bus stop, trying to figure out, pacing back and forth, what am I going to do?
So you're kind of standing in the same general location.
Right,
And no one else is around you.
correct. And then a truck just appears out of nowhere, and Mr. Tillis basically opens up the passenger door and kind of signals to come in. And without thinking, you know, I just want to go home. Hey, maybe this is a ticket out. I don't have to worry about trying to get home to my mom. Maybe he'll help me. So I end up getting in the car, moment of silence, not even a moment later, he pulls right into a parking lot that's like a vacant lot. It's not even a parking lot, not even a couple feet ahead. Basically, before he even turned, I was explaining in a way like, thank you for picking me up. I just need to get home. My best friend left me and I just want to get home. And there was just nothing but silence. And all of a sudden, when he turned into that vacant lot, he put the car in park, turned off the car, and right then I knew it was trouble. Something bad was going to happen to me. And sure enough, right as I go to look over at him, all I feel is a big slap in my face. He backhanded me really hard on my face.
Okay, so you were just a few hundred yards or so from where he picked you up.
Right. It was right there.
And what time of day are we talking about?
It was right before dusk. By the time he shut the car off, it was pretty much dark at the time. The sun was just about to set, and that's when it got dark. It was dark at the time, when
And so the slap was with the front of his hand or the back of his
the
hand?
back of his hand.
Did it hurt?
Oh, yeah.
All right. Tell the jury what happened after that.
Then adrenaline kicked in, and I'm freaking out, not knowing what I'm going to do, thinking, how am I going to get out of this? Praying in a sense. And all he does is he basically unzips his pants, and he basically told me to take off all my clothes or he'll kill me, and told me to put my mouth on his private part. And as I was doing what I was told, fearing for my life, I remember getting up for air, whatever, and a thought came into me, and that's when I knew I had to pretend that I did this for a living. So fearful for my life, he would try to kill me now that I saw his face. God knows what's going through his mind. I told him, you didn't have to do this. You didn't have to slap me. I do this for a living, basically.
You told him you were basically a prostitute.
Correct.
Were you a 14-year-old prostitute that goes to Jeb Stuart Middle
No,
School?
never ever was a thought in my head to do that to myself. I had bigger and better plans for myself, and I respect myself and my body as a temple. And for me to get violated that way,
Okay, let me ask you this, so you saw him, is this person, could you describe him, how old? Was he in his 20s or was he older than that?
40s, definitely his 40s.
And so, you were describing coming up for air, performing oral sex, and you told him he didn't have to do this. What happened?
A sign of relief hit his face, and basically, he told me that if I can remember, like, you could do this all day and I still won't get off, so I need to basically have sex with you. And then he penetrated me. He basically burritoed me. My legs were all the way to my head as he penetrated me. And that whole time I just prayed to God that I would survive this and that I would have died, that he'd let me go, and that he would believe me. And then after that was over, I saw as he ejaculated in a piece of napkin that he had behind his chair, basically. I saw a wallet, I grabbed it, thinking that's his identification. When I get out of here, I'm gonna report him. And then all of a sudden he was freaking out, where's my wallet, where's my wallet? So I had to pretend like I had to put it back so he wouldn't notice that I took it and searched me or whatnot. And he took his wallet, and he pulled out a business card, and he said, here, we should do this again sometime, maybe for like an hour. I'll pay you good amount of money, maybe $100. And then that's when I said, okay. And then as he turned on the car to leave to take me home, supposedly, he said, you know what, forget it, give me my card back. I don't want to. Or I guess he had a feeling that this wasn't sincere, that he might get caught, and God knows what he was thinking. So he took his card back, and that's when...
Did you go to another location?
Yes, as I told him where I didn't want to bring him all the way to my house. So I told him to drop me off at my friend's house, basically, which was on Seaboard.
Did you see what he did with the napkin?
He threw it outside the window, and that's when I was going for his wallet.
So he's taking you to Seaboard, which is just a little ways away from there?
Right. He took me towards Seaboard, and Vista Verde is where April lived with her dad. And I told him to turn right there on Vista Verde, and he kept going. And I said, you missed the turn, and he said, I don't want to do it again. And then that's when he went to the next location. So he went all the way down. I think that was passing Timuquana to apartments. I don't know. I'm not familiar with. He parked right there in the apartments and made me perform oral sex and then penetrate me again.
Do you know if he ejaculated on that occasion?
I'm not sure at that point. My mind was just discombobulated. I couldn't think at the moment. I don't remember or recall.
So after that second assault, what happened?
That's when he finally took me back. He paid me $40, and I made him drop me at the beginning of Vista Verde so he wouldn't go all the way down and know where April's dad lived, because I didn't want him to, God forbid, come back again.
And then what did you do after?
I got out the car. I went straight to April's dad. I thought maybe April would have been there by now, but she wasn't. I cried and cried. I told April's dad what had happened, that I was raped, and he's freaking out. He called April on her phone and said, what happened? What did you do? Why did you leave Brisha by herself? Get your behind here now. And that's when, probably 15 to 20 minutes later, she rushed back, and I told her what happened. At first, she didn't really believe me until the next day after school, which was Tuesday. I showed her the spot where it had happened, the first location, and I showed her where the napkin was, and that's when she believed me. And I ended up finding a nearby bag and I wrapped it up. Something just told me to do that, so I followed my instincts, bagged it up, left it there. We were going somewhere else, so I didn't bring it with me. And then after that, the next day comes, and I told my friends at school. I even remember walking home again with April that following day. And then another friend, I can't recall her name, she had the smell on her, and it was the smell of same exact of him, and it reminded me of it. I don't know if I told you guys, but it was the green Axe, and she's like, yeah, spray this on me. And I'm like, I never want to smell that again. That was what he was wearing. I could tell, and it just reminded me of it. And then that's when I talked to some people at school about what happened, and they said, you know, you need to not just keep it to yourself. You need to go out and tell somebody so it never happens to someone else again. And that's when, that next day I went to my mom, and I just got home and cried, and I told her what happened, and that's when she called the cops.
Was it hard to tell your mom?
Oh yeah, it was. She's like, what happened? How did it happen? And I gave her just the basics and left it at that. And that's when someone came, and I gave my report, I think, to a police officer about the report. And then that's when I went to go get testing. My first time ever getting like something inside me to test me, like a pap smear almost. First time I've ever got that done at the age of 14.
So you went to you got checked out to make sure you were okay.
Correct, and they also found a hair, they said.
And later, were you able to identify the defendant by looking at photographs?
I did.
Did you also provide a sketch of the defendant?
I did.
The sketch, was that pretty close to what the defendant looked like?
Pretty close.
And then later you learned that the napkin that you had, that you went back and got, matched the defendant.
Correct.
And was the defendant convicted of child abuse as a result of what he did to you?
Correct.
Have you provided the state of Florida with a photograph that shows how you would have looked back in 2006?
Yes.
And I approach the witness.
You may.
I'm showing you the areas of evidence, the cases of the 114.
Yes.
You see that? Is that a fair and accurate depiction of the way you looked around that time?
Yes, sir.
Can I publish your honor?
You may.
Your Honor, that's all the questions I have.
Okay. Mr. Maris? Okay. Thank you, ma'am. You're free to go. Members of the jury, let's take a brief morning recess, just a brief recess. Remember, same rules apply from last week. Do not discuss the case. Leave your pads on the chair, and we'll see you back in a few moments. We'll be in recess for a few minutes.
car started to sputter, and I just made it on the side of the road. It just died.
And so you were able to pull off on the shoulder?
Yes, it was.
Okay. Was it getting dark at that point in time?
Yeah, it was getting pitch black about 7 o'clock. I was still there.
And did you have a cell phone of any kind back in 1989?
No, I did not.
Now, ironically, had you just actually purchased AAA?
Yeah, I got it that day in the mail, my AAA card.
When you had car trouble, did you have any way to call the police or FHP or a tow truck?
No, there was no one around.
Now, you stated you were able to pull off on the shoulder. How long were you actually strike that? What was your plan? What did you think you were going to do sitting on the shoulder of the road?
I was hoping a police officer would drive by, and I was waiting as long as I could. I was there for over an hour, and it was just pitch black and nobody, just some cars running by.
I would imagine you were scared?
Yes.
Okay. And did you ever see a police car or a highway patrol or anyone to help you?
No, there was no one around.
At some point, did someone stop and pull off the side of the road?
Yes, Mr. Tillis pulled over, and my hood was up, and he looked at it and see if he could fix it, and he just didn't really do anything. That was.
Can you describe to the jury what, and I know you say to Mr. Tillis, but just so it's clear, did you know Mr. Tillis at all back then?
No.
So he was a stranger pulled off.
Absolutely.
Okay, and can you describe what the individual looks like back then who stopped?
He was a clean-cut guy, nice-looking guy, clean-cut.
You remember what kind of car he was in?
He was in a pickup truck.
And you stated he got out and kind of checked and said he couldn't help.
Yeah.
What did you ask him to do?
I asked him, I said, I just got AAA, and if he would go call the number for AAA for me.
Was it fair to say you essentially wanted him to go to either like a gas station or somewhere with
Correct.
a payphone or a phone to use
Yes.
to call for help?
Yes.
And what did he tell you?
He said he wouldn't do it. He said he would drop me, but he wouldn't do that phone call.
As you were having these conversations with him, were you toying with the idea of whether or not you should get in that truck?
Absolutely.
And what did you eventually decide to do?
Well, I was afraid to stay there by myself, and it was nothing. There was nobody on the road, and I was afraid to stay there more than get in. It was pitch black, nobody was around, and I didn't know what to do.
Ms. Leon, did you eventually get into the truck?
I did.
And did you get into the passenger seat?
Yes, I did.
Was anyone else in the truck?
No.
Did you get in thinking he was going to then take you to a gas station or get help for your car?
Correct. I thought a 7-Eleven or a gas station, yes.
Okay, and can you describe for the jury this part of I-75 for them, especially how it looked back in 1989?
Yeah, there was nothing. The exit was maybe a few miles away. I wasn't even sure how far the exit was, so there was nothing there. It was completely just the road, no businesses or anything on it.
What happened once you got in the truck?
He fell eerily silent, and I knew something. I kept trying to elicit a conversation, and he just wouldn't say anything to me. And then I knew something was wrong, right, just in my gut.
And can you explain to the jury the path he took in the truck in terms of where he drove you?
Yes, he drove off he took an exit off the interstate and drove back into a construction site, and there was nothing there. It was just like mounds of dirt and nothing else there.
Based on how he was driving, did you feel like he was familiar with that area?
Yes.
And did you ever pass another car as he was driving?
No.
Did you, while you were in the truck with him, were you trying to get out?
Yes, when we stopped, yes.
And where was it that he stopped the truck?
He stopped in the back of this construction site by this big mound of dirt, and there was a little ditch beside it, and nothing else was around. Nobody was there. It was just no lights, no anything.
And you mentioned a little ditch. What thoughts were running through your head at that point in time?
My mother and I were very close, and at the time, she had just given me her ring, and I thought they were going to find my body down in that ditch, and that's what they would find.
Your ring?
Yeah, just to recognize me with that.
When he stopped the truck, what happened?
Well, he just kind of attacked me and choked me, grabbed my breast, and whenever would give in, he would stop, and then I would try again, and he just kept choking me until I'd kind of get lightheaded, and then I would get afraid and just stop fighting. I tried to kick the windows out. It was a little pickup truck, so it's hard to get any leverage in there to do anything or fight anybody.
Ms. Leon, you stated, I think, that you would give in. Can you explain to the jury, like, I guess, how aggressive he was being? Why would you be trying to give in?
Well, because I knew he was going to rape me, and I didn't want that. But then I didn't want to be strangled, so I didn't know what to do.
Was he choking you, Ms. Leon, to the near point of blacking out?
Yes,
And was that a repeated violent act that he was doing?
yes,
I take it you were similar size to how what you are today?
yes.
Okay, and how tall are you?
I'm 5'2".
Ms. Leon, what happened next?
Well, it went on for a while, and I was just ready to stop and let it go. And he looked over, and there was 2 headlights coming at us. And there was nothing else there but these headlights coming in. And he just jumped up, and I grabbed the door handle and pulled the lock up and rolled out.
You mentioned the door handle. During the time when he was choking you, were you able to get to the door handle during that point in time?
No, he kept slamming the door. Yeah, I couldn't get out.
And you stated you were able then to roll out of the car, essentially, once you realized there were some headlights there.
Yes,
And did his car take off immediately?
immediately.
Okay, and what did you do at that point in time, and how were you feeling?
Well, there was two guys in the other truck, and I was afraid of them. I didn't know. They, the long beards, and, you can't judge a book by its cover, but they actually saved me.
And what was your demeanor, to the best of your memory, like as these 2 men approached you? Or
Well,
you approached the 2 men?
I was pretty crying and pretty upset.
And did these 2 men, did they offer to help you?
Yes, they did.
And what did they do in terms of helping you?
They went back and fixed my car, and then they drove me to a hotel. They actually called my mother for me, and then that was it. And then they left.
Okay, and did you learn from them anything about the person who had picked you up?
I did. He was an iron worker on the site, and he would sleep there illegally. So they knew him from there.
So was it just by chance that they happened to see his car that night?
Yes.
Now, that night, did you go back to your house in Sarasota as opposed to going to your mom's?
Yeah, I drove home. It was closer than Crystal River, and I didn't want to stay alone in a hotel.
And did you also notify the police of what had happened?
I did when I got home.
And my understanding is that you then actually met the police the next day
I did.
back at the scene of where this had happened?
Yes.
And when you got back up there, could you find the exact place where the defendant had tried to rape you?
I knew exactly where it was in the daytime. I even found some stuff that came out of my purse, some papers and stuff, and a necklace. Yeah.
And my understanding is that you were missing your identification for a while?
Yes, for a year.
And how did that make you feel?
I slept with a bat beside my bed for a year. I was so afraid that he would know where I lived and come after me.
Did you have any physical injuries or soreness from this attack?
My neck was sore and red.
As part of the investigation, did law enforcement eventually show you what's called a photo spread?
Yes, they did.
And were you able to pick out the person who had kidnapped you, and tried to rape you from the photo spread?
Right away.
And do you see that individual here in court?
I do.
Can you explain where he is seated and describe something he's wearing?
He's sitting over there beside on the defense table on the end.
And can you describe something he's wearing or something he has on?
Yes, he has a suit on, a gray suit, and hair pulled back in a ponytail.
May the record reflect the witness has identified the defendant?
The record shall so reflect.
And that, Ms. Leon, is the same person, the defendant, Russell Tillis, that you picked out of the photo spread?
Correct.
And was Russell Tillis convicted then of kidnapping?
He was.
Your Honor, I have no further questions.
Okay. Any questions for the witness? No questions. All right, thank you, ma'am. You're free to go.
Thank you.
State.
Your Honor, our conclusion of the aggravating factor presentation will be the introduction of judgment and sentences. First, State's Exhibit 115, judgment and sentence for kidnapping. And that has been entered into evidence. States 115. Additionally, a judgment and sentence for kidnapping, States 116. Evidence, and the parties stipulate these are the judgment and sentence of Russell Tillis.
Okay.
At that point, that concludes our aggravating factors, Your Honor. We now have victim impact evidence to present.
Okay, you may proceed.
State would first present Darlene Johnson to read her impact.
The witness will not be sworn in for this presentation. She can proceed to her seat.
Ms. Johnson, could you just make sure you speak into the microphone, and if you could just state your name? Oh. May I approach the witness, Your Honor?
You may.
That's okay. Can you read your impact statement? Your statement?
Let me read it.
Yes.
Jody was a happy child. She always wanted to help her classmates with her schoolwork. She was a great sister to Ashley and Robert. Robert has epilepsy. Jody would always look out for her sister and brother. When other kids would come up and pick on Robert, Joni for him, especially when they would come up behind him and scare him, because that would trigger an epileptic attack. Holidays like Christmas or birthdays were great. She was always very appreciative and happy with whatever she got. Growing up, when they were all playing school, Joni always wanted to be the teacher. When they played house, she wanted to be the mom. She was a leader for her brother and sister. When Joni was little, she would sing all the time, and she always made Mama happy. I grew up playing baseball with my family and did the same with Joni, her brother and sister. She liked sports and loved being with family. After we tragically lost her mother, my daughter Linda, they were placed in foster care, although they really wanted to stay with me. I wasn't permitted to take them in because the state said I didn't have a job or car to provide for them. I had a good neighbor that offered to provide transportation anytime we needed it, but that wasn't enough. I miss them all and wish I could have taken all of them in. Joni's son, my great-grandson Dominic, was born November 9, 2008. I was able to take Dominic in to help care and provide for him when he was 2 days old. Joni got pregnant prior to running into some trouble. I was not aware that she was pregnant until her sister Ashley told me, and I received a letter from Joni prior to Dominic's birth that another family was lined up to take Dominic in. She said she wanted me to take him in because she stated family comes first. I have raised Joni's son as my own, but he has her last name. Everybody in my town tells me that I have done a good job in raising him. Even his teachers say I'm doing a good job because the love I have for Dominic, the reason I am committed to raising Dominic to be a good young man is also for Joni. She would be so proud of the young man he has become. I wish she could see him today. When we go to the store, Dominic introduces me saying, "This is my great-grandma," but I call her Mama because my mama was murdered. Dominic asks me about Joni sometimes, normally when he dreamed about her. I will share pictures of her when she was little, along with memories and stories, which is all we are left with now. Thank you, Darlene Johnson.
Thank you, Ms. Johnson.
Thank you.
Johnson, you're free to get off the witness stand.
Ms. Wilson?
Your Honor, the second impact statement would be from Ashley Gunter, Joni Gunter's sister.
And she can proceed directly to her seat.
And Ms. Gunter, you can go ahead and read your impact statement for the jury, please.
My name is Ashley Gunter. I'm Joni Gunter's baby sister. Let me start by telling you that Joni was a very free-spirited, caring, talented, funny, giving, and caring. She had a beautiful soul. No matter what life brought her or what she went through, Joni always said, "This too shall pass." When we were younger, we used to go to visit my grandmother's house a lot. My grandmother had many cats, more cats than I have, and I have 20-something at my house right now. She had a whole bunch of cats, and one had kittens. Joni had a contagious laugh. When she would start laughing, I couldn't help but start laughing too. One of my favorite memories of her was when she hid behind the dryer. I kept hearing a cat meowing near the dryer. I thought one of the kittens was stuck in the dryer. I opened the dryer door, and there was no kitten in there. Joni jumped out and started laughing. She was such a prankster. Joni liked to swim and loved the water. Growing up, we swam a lot. We would go swimming in the Camp Blanding lakes with the daycare and through our times in foster homes together. On one occasion when I was 7 and Joni was 11, I wanted to do a backflip from the diving board. With my back to the end of the diving board, I asked Joni if I was at the edge of the diving board. She said, "Oh, yep." I attempted to do a backflip, but quickly realized too late that I wasn't at the edge of the diving board. She also tried to drive a four-wheeler, but that didn't go well at all. We ended up in a ditch. When we would go to Six Flags, she liked to ride the Mind Bender roller coaster. Joni was always having fun. and full of life and loved the rush of adrenaline. Joni was a great big sister. She was very protective and tried not to leave me alone with boys and was looking out for me in all a big sister would. In all ways a big sister would. Joni was also giving, a giving person, never selfish, always giving. Giving was never an issue with Joni. She had a giving heart. And no matter what she had or didn't have, she had no problem giving her last dollar or anything else she had to someone in need. Anytime we went out to eat somewhere, if we had leftovers, we would make it a point to give them to someone who was homeless. She taught me so much about care, love, and giving to others. Joni and I loved to sing. She had a beautiful voice. She carried a notebook with her that she wrote poems and songs in. She was so talented. Joni, our brother, and I wanted to create a band, and we wanted to call ourselves Shooting Stars. My sister and I both played keyboard, and she played guitar sometimes. All three of us were going to sing, but she was going to be the lead singer and songwriter. Robert was going to play the drums, and I was going to be on the keyboard. When I was 18, she wrote a song, and she wanted me to make my own verse for her. And it went, "Don't cry, my angel, don't shed a tear. I'll still be here holding you near." That's the verse she wrote, and she wanted me to write my own version too. When Joni and I were in separate foster homes, I called Delilah's radio show and dedicated a song to her, "A Big, Big World" by Amelia. When Joni heard the dedication, she called me and said, "I love you, Ashley. I miss you so much." The following weekend, I went over and spent the night with her. We made it our song. That is our song. Now the song I dedicated to her is "Dancing in the Sky" by Danny and Lizzie. My favorite line is, I hope you're dancing in the sky. I hope you're singing in the angels' choir." That's my favorite part because she loved to sing and had a beautiful voice. My grandmother took her baby in. She always wanted to get us back together, get all three of us together, but my grandmother will never be given that chance. Joni will never get to see her niece grow up. Her name is going to be Serenity Hazel Lynn. I miss her laughter. I miss seeing her walking down the street, coming towards me. I miss talking to her, her voice, her singing me to sleep. I miss her so much. I still have so many questions I want to ask her. Thank you, Ashley Gutson.
Thank you, Ms. Gunter.
Thank you. Mr. Mizrahi?
Now, that concludes the state's presentation.
Thank you, sir. Mr. Maris, Ms. Miller? Okay. Members of the jury have a matter to take up outside your presence. During this break, as with all breaks, do not discuss the case, and we'll see you back hopefully in a few moments. Proceedings, Ms. Miller. Morning, sir. Thank you, sir. Have a seat.
Ready?
Yes, ma'am.
If you could please introduce yourself and spell your last name.
Ronald D. McAndrew, McAndrew.
And what are you currently doing for work, sir?
I'm a prison and jail consultant,
How long have you been doing that?
about 16 years.
Before you became a prison consultant, how were you employed?
I was employed by the Florida Department of Corrections.
And I'm going to walk hopefully through all of it, but what was your last employment before leaving employment with the Florida Department of Corrections?
I was the warden at Central Florida Reception Center, but still under state retirement. I worked for a year as the director of the Orange County Jail.
And correct me if I'm wrong, the Central Florida Reception Center is also in Orange County, is that correct?
It is, ma'am.
Okay, and so you were at CFRC and then went to the Orange County Jail, and that's where you retired, is that correct?
That's correct.
Before you were at the Central Florida Reception Center, where were you employed? Which prison facility?
I was the warden at Florida State Prison.
In the Florida State Prison, when you were the warden there, is that where Florida's death row was housed?
That's correct.
Is that where Florida's death house, where the execution chamber was housed?
That's correct.
Now, in 2021, death row is at Union Correctional Institution, is that correct?
The inmates are housed at Union Correctional, but the death house itself is still at Florida State Prison.
And Union is less than a mile down the road from the Florida State Prison?
About a half a mile.
Okay. And so the inmates are housed at Union, but when they're put to death, it still happens at Florida State Prison, correct?
That's correct.
When you were the warden at the Florida State Prison, did you have occasion to preside as the warden over executions?
I did.
How many?
3 at Florida State Prison, and I worked with the death team for 5 lethal injections in Huntsville, Texas.
Have you ever testified before today as an expert in prison consultation?
I have, many times.
About how many times, sir?
I've testified in state and federal courts, the New York State Court of Claims and the High Court of Dublin 140 times.
Let me ask you this. Every time a defense attorney, such as myself, calls you, you end up on the witness stand.
I do not.
Do you take every case, I guess is another way of saying that the defense tries to hire you potentially for the benefit of the defendant?
I do not.
And why is that?
Well, in the initial discussion, if I learn that the inmate has an atrocious disciplinary history, of course, I would be working for the state attorney as opposed to a defense attorney.
And so if you end up on the witness stand, it's typically because the defendant, not typically, it's always because the defendant does not have that atrocious prison history to use your words.
Well, to answer that question, I must say that I also do a great deal of civil work. That's about half of what I do. And I have, in fact, worked for the state attorney.
I got it. And that's probably the question I should ask you next. How many times have you been retained to work professionally as an expert by law firms or others?
577 times.
Let's start a little bit before that. What is your educational background, sir?
I have an AA in Criminal Justice Administration from Miami-Dade Community College. I'm a certified public manager through the Center for Public Management at Florida State University. That's not a bachelor's degree. It's a 2-year part of Governor Lawton Child Sterling program. Pass-fail certification, state certification. I've had 12 career development courses, all designed and sanctioned by the Florida Department of Law Enforcement and taught in community colleges around the state on a pass-fail basis. I have countless seminars and special training events related to corrections during my career.
Obviously, you've spent a large portion of your career working within the Department of Corrections or the prison system. But before that, what is your employment or work background?
The United States Air Force for 4.5 years. I served in France and the Belgian Congo. I worked for a French firm in France, the Middle East, the Far East, and Southeast Asia for 18 years. And then I joined the Florida Department of Corrections early in 1979.
Okay, so now we're at DOC, what's commonly referred to, Florida Department of Corrections, DOC?
That's correct.
Okay.
FDC.
I think, use a lot of acronyms in this business. Would you agree?
They do. DOC is the Department of Commerce. FDC is the Florida Department of Corrections.
Excuse me. Tell me about how you worked yourself up the ranks through the Florida Department of Corrections.
I was hired at the lowest pay grade of a recruit correctional officer. I worked my way up through the ranks of certified officer, sergeant, lieutenant, captain, investigator, inspector, major. I skipped over colonel and I was appointed as a deputy warden in 1988. In 1992, I was appointed as the warden to open up a new prison in the Panhandle in Weewha-Hitchcock, Florida. In 1996, I was appointed as the warden of Florida State Prison. 1998, I was appointed as the warden of Central Florida Reception Center. And as mentioned earlier, I spent a year running the Orange County Jail with the understanding that I was doing that contingent upon the county doing a national search for a new director.
Total of 23 years with the Department of Corrections?
That's correct. And I was allowed to purchase 4 years of my military time and apply it, so they gave me 27 years credit for retirement.
The Florida Department of Corrections has its own internal manual policies for governance, correct?
It does, as long as they don't supersede the Florida Administrative Code or Florida Statute 944.
And during your years with the Florida Department of Corrections, did you have occasion to become familiar with those policies, rules, and professional conduct regarding the Florida Department of Corrections?
Thoroughly.
Tell us more about that. Did you have anything to do with writing any of those policies?
I wrote and rewrote many of the policies of the Florida Department of Corrections. I am the co-author of the emergency plans for the Florida Department of Corrections.
And so the policies for the Florida Department of Corrections, do those involve the discipline of inmates that are confined in prisons in Florida?
That's correct, to do.
Maybe just quickly, tell us what the difference is between prison and jail in Florida.
Prison is where you have been sentenced. Jail is where you're either serving less than a year or you're pending trial.
Okay, so if you are a sentenced inmate sentenced to more than a year confinement, you're in prison in Florida?
That's correct. Most of the time.
Right. Absent some circumstances with transportation and that sort of thing.
Well, sometimes jails, they have consecutive sentences and things like that, so someone could actually wind up in a jail for more than a year.
And I want to talk to you a little bit, too. The Florida State Prison, when you were there, housed the death house and death row, but there were also inmates, on what a lot of us call the compound, serving life in prison or term of year sentences. Is that correct?
The vast majority. In fact, the population was about 1,100 or 1,200 at the time. And of the some 400 inmates on death row, Florida State Prison housed about 100 of those at that time.
Similarly, at the Central Florida Reception Center, obviously there are no death sentence inmates there. You would have inmates that are sentenced to lesser terms of prison confinement, correct?
Yes.
And the other facilities that you were at, Gulf, they also would include inmates serving terms of years or potentially life in prison without the possibility of parole.
Both, yes.
Did you, as the warden at the Florida State Prison, work with the staff in the Florida Department of Corrections, or in that particular prison?
Indeed, yes,
Did you also work with inmates?
closely.
Tell me about that. The prisons run largely based on inmate labor, is that fair?
95% at least of the labor done in the Florida Department of Corrections is done by inmates.
And so I want to take a little bit of time to discuss what a inmate who is sentenced to die, what his typical day would look like on death row. If you could walk me through that, please, sir.
Yeah, I'm going to object at this time. May council and I approach? Socially
Well,
distance, of course.
I'm sorry?
Socially distance, of course.
Do you need Madam Court Reporter?
Maybe, but I think we can approach first, and then
All right, come on up.
we'll make a decision.
Where's that noise coming from?
Thank you, sir.
Hold on one second, Ms. Miller. Where is that coming from? From before?
Buzzing?
Yeah, there it goes.
I think I got it. All right, Ms. Miller, go ahead.
Thank you, sir. So, Mr. McAndrew, I want to take a little bit of time to discuss the difference in day-to-day life between death row and somebody who's serving life in prison without the possibility of parole, okay?
Yes, ma'am.
And so, generally, somebody who is sentenced to die, what does his or her day look like? I guess his at the Florida State Prison.
Well, he or she lives in a single cell, alone, private cell. They have their own toilet jacket and sink inside the cell. It's about 6 by 9 feet in terms of square square feet, about 60 square feet. They have a steel bed with a mattress. They have their private television and their own private tablets. They have 12 channels that they get from an antenna. Most of the time they get 12 channels. Sometimes there's less. They are taken out of their cell 3 times a week for at least 2 hours, or 2 times a week for 3 hours each time to play basketball with other inmates on death row. They are not allowed to work under any circumstance. They are escorted from their cells by officers to the shower 3 times a week. They send their dirty laundry out and it's brought back to them. The nurse comes to their cell every day and asks if they have any medical issues. They're allowed visitation as long as their conduct is appropriate. They can declare a medical emergency, and they are then escorted to the medical department to be seen. Otherwise, that's pretty much the day of an inmate on death row.
I've answered this and I missed it. Or do they even do their own laundry?
No.
They're not allowed to work at all?
Well, sometimes they'll wash private pieces of clothing in the toilet and dry it under their bed. They're not really supposed to, but it does. It happens a lot.
I mean, I guess occasionally they clean their own bars to their cell.
I'm sorry, I didn't follow that question.
Occasionally the inmate might clean their own bars to their cell.
Yes, they would. Or they're clean from the outside.
I think the point you're making is that there's really limited movement for those inmates, and so they're not able to do anything to benefit the prison, as we talked about earlier. Fair?
They're not allowed to work under any circumstance.
Now I want to talk about an inmate who's serving life in prison without the possibility of parole. Tell me just generally what that inmate's day looks like.
He's considered an HO4 or an HO5. That means that he's going to be close custody forever. He's going to live in a confined building, not an open bay. That he will be confined in a cell with at least one other inmate. That cell will be locked every night, and it will stay locked until breakfast the next morning. They are not allowed to go into any other dormitories. If they go outside the building any time after hours, it's in handcuffs and by officer escort. And that's rare. It's only for medical reasons and that sort of thing. They are allowed to work. Not only are they allowed to work, they're required to work. If they refuse to work, they'll go to close confinement, and that's the most severe punishment in the Department of Corrections. They're allowed to, their work is reviewed monthly by their classification team. If they have special skills, the Department of Corrections likes to use that because a great deal of the construction and rebuilding and reconstruction and repairs are done by inmates. On a compound with 2,000 inmates, they configure approximately 11,000 toilet flushes per day, which means there's a lot of toilets to be repaired around the clock. Hot water for showers. Can't run out of hot water, so you need inmates that are trained to operate boilers. All of the electrical repairs are done by inmates under the supervision of an electrician. The painting, which there's always repainting to be done. All of the janitorial services are done by inmates. Orderly work, everything from a medical orderly to the orderly that works in the warden's office is done by inmates. They're library clerks, they're law library clerks. They're paralegals that are inmates that help other inmates with their legal issues. This, of course, saves the Department of Corrections a great deal of pain and strain in terms of inmates being able to have due process. They're allowed visits in the visiting park, just like those on death row, but under supervision, and the types of visitors and the number of visitors is closely scrutinized.
And are their visitation privileges limited if the inmate doesn't have good behavior?
Oh, they're restricted completely. In fact, an inmate can lose his visiting privileges for 6 months for a disciplinary infraction.
As you said before, if the inmate is unwilling to work, he's going to be disciplined by the Florida Department of Corrections.
Without question.
And it's fair to say that Florida Department of Corrections needs people who have trades in welding and mechanics and those sort of things for the infrastructure of the prisons.
They do indeed.
Let's turn to Mr. Tillis's case specifically, okay? What were you asked to do in this case?
I was asked to take a look at his past record in the Department of Corrections and the Duval County Jail. I was asked to visit with him, have an interview with him, and fill in any of the blanks that I might have had. I did those things. And I was asked to provide an opinion to the representative attorneys of my professional opinion of his propensity for possible problems in the future.
And you touched on this. Tell me exactly what you reviewed in coming to ultimately have an opinion about whether Mr. Tillis is going to be a problem in prison or not.
I reviewed what's commonly referred to as a DC-14. That's a printout of a chronological order of all of his institutional assignments, work assignments, disciplinary history programs, job assignments, all of that. It's a picture in 7 or 8 pages of his entire incarceration.
And that includes his whole life, essentially.
That's correct. I also reviewed his Duval County disciplinary history records.
Okay. And so let's talk about that. The Duval County jail records you reviewed, that is while he's been awaiting trial for this case, correct?
For the past 6 years, yes.
What did your review of those records show?
Zero discipline, none whatsoever.
And, you know, we kind of skipped over this. What can an inmate get a disciplinary referral for?
Practically anything. Talking too loud while the television's on. Being in the wrong cell. Refusing to sweep up your cell. Refusing to maintain proper hygiene. Disrespect to an officer. Fighting. There are 1,000 reasons that they can receive disciplinary reports for.
So it ranges from anything to talking back to a deputy who asks that inmate to do something, right?
That's correct.
All the way up to getting into a fight with another inmate or a deputy.
Or arson, or murder, or escape.
And in your 23, 27 years with the Florida Department of Corrections, the Orange County Jail, have you seen those things happen in the prisons and the jails?
Many, many times, yes.
The whole gamut from A to Z?
From murder down.
And so, if I understand you correctly, Mr. Tillis has gotten no disciplinary referrals whatsoever the entire time he's been in the Duval County Jail awaiting trial for this case.
That's correct. In fact, he had no discipline for the past 17 years plus.
And that's what I wanted to go back to that. So obviously, we've heard testimony, and you were here this morning, and have heard some of that testimony as well, that Mr. Tillis has a prior criminal history that landed him in the Department of Corrections, right?
That's right.
And that's that DC-14 that's a synopsis of his prison history.
Yes, ma'am.
And since 2004, has Mr. Tillis had any disciplinary referrals from the Florida Department of Corrections?
None.
Not a single write-up.
Not a single disciplinary. Astounding.
In the DC-14, was it also able to show you whether or not Mr. Tillis worked while he was in the Department of Corrections?
It did.
And what did it tell you about Mr. Tillis's work history?
He had a number of job assignments. He had a lot of the common assignments like inside grounds and houseman and what have you, but he also worked in the library as a library clerk, and he worked in construction, helping rebuild butterfly dormitories.
So despite the fact that he's 60 years old, would you anticipate if he were sentenced to life in prison without the possibility of parole that he would be expected to work?
If he was in a wheelchair, he would have a job assignment.
Something obviously non-physical, but he would still be expected to work and contribute to the prison community.
Yes, ma'am.
Mr. Tillis did have some disciplinary referrals between 1995 and 2004, is that correct?
He did.
How many?
I think there were 12 or 13. I don't remember the exact number, but they were all very minor charges. There was one charge for fighting, which is very common.
Fighting with another inmate, correct?
Fighting with another inmate.
And so would you consider that largely nonviolent minor for the Department of Corrections standards?
I would, yes.
What is your professional opinion of Mr. Tillis?
He's without question a compliant prisoner. He's obviously done some very serious growing up over the years in prison. He has a genuine respect for the rules and regulations. He has a desire to work. He indicated to me that through his own way of life, he was going to, by his own natural presence, would like to set an example for younger inmates, and that he would like to make a contribution as opposed to being a burden.
So some of the things you learned in reviewing the DC-14, which is history that's documented by the Florida Department of Corrections, and some of the things you learned actually from having conversation with Mr. Tillis, is that correct?
That's correct.
That's when you talk about his desire to want to make a contribution, that came from your conversation with him, is that correct?
That's correct.
Sorry, can I move around? Can I-
Sure, yes, yes.
Go, Mr. McKee. Andrew, request. County Jail.
Yes, ma'am, it is.
That confirms there were no disciplinary referrals related to Mr. Tillis from the jail pending trial for this case, correct?
It does.
Have just a moment, Your Honor.
Yes, ma'am.
Questions. In reviewing the DC-14, did Mr. Tillis, has he availed himself to classes and courses offered by the Department of Corrections while in prison?
He has.
And those get more and more limited as budgets get tight, correct?
That's correct.
But he's taking, it seems, what's available to him?
That's the only way, yes.
And we talked about, obviously, the Florida Department of Corrections being in need of welders and mechanics and maintenance. You're aware that Mr. Tillis is those things by trade, correct?
He is a certified welder, an iron worker, an automotive mechanic, a radiator repairman, He's had some serious work history.
So obviously, as we touched on, but specific to Mr. Tillis, if he was sentenced to life in prison without the possibility of parole, he would be required to work, presumably in the fields of his expertise, which would benefit the Florida Department of Corrections, correct?
He would work 40 to 50 hours a week at whatever job assignment he was given.
And the Florida Department of Corrections would not have to hire outside people.
Objection, Your Honor.
Sustained.
I have nothing further, sir.
Okay. State.
Andrew, thank you for your service to our country and the state of Florida. I have just a few questions for you, okay?
Thank you, sir.
You're welcome. I want to go over a little bit of the times that the defendant, Mr. Tillis, was in and out of prison, because you've reviewed those records, correct?
I did.
Okay. So my notes, do you have the printout in front of you? Just want to make, I want to make sure my notes are correct.
I have his DC 14, as we
Yes,
talked
sir.
about
Very
earlier.
good. And my notes, and correct me if I'm wrong, show that Mr. Tillis, and I'm going to just give the month, not the date, but from April of '94 until March of '98, he was in Florida Department of Corrections custody.
That's correct.
And then from August of '98 till August of '99, he was in custody.
I believe that's correct as well, yes.
And January of 2000 until September of 2004.
Yes, sir.
And then August of 2008 until February of 2012.
February 6th, yes.
And then, obviously, from May of 2012 until now, he was in the Duval County Jail.
That's correct.
Okay. Now,
Ms. Rahi, you said 2012 to know.
I'm sorry, you're right, I wrote it down wrong.
2015.
Yeah, that's why I got, so yeah, May of 2015 until now. So the dates that he would have been out would have been 2012 till 2015.
Yes, sir.
Okay. Now, Mr. McAndrew, those dates are just the dates that the defendant would be in Florida State Prison, correct? Excuse me, yes, Florida State Prison.
I don't follow that question, I'm
Here,
sorry.
my question is, for example, if you were to pull Mr. Tillis's record when he gets sent to prison, it would not show dates from 2015 till he gets sent.
Yes, sir, those records would show his jail time as well.
The county jail sentences count as part of this in and out? In other words, the time that they're waiting is going to be reflected on that sheet?
It would be, yes, it would show him out to court
Even
and
before
to
he's-
whatever county jail he was in.
Even before he's been convicted?
Yes, sir.
Waiting for trial. Okay, I didn't know that. So how about the gain time that a person gets while they're in Florida State Prison? Explain how that works.
Well, ordinarily inmates are given a number of days of what's called good time or gain time at the end of each month based on the work report. In other words, they did a good job. They showed up on time every day. They weren't tardy. They didn't give anybody a hard time. They'll be given some gain time days. But in the case of someone with life without parole, these dates are recorded. But the only reason they are recorded is in the event that the U.S. Supreme Court should change.
Sustained.
By the way, elicit that. But what I tried to elicit, Mr. Victor, I think you were getting there, is a person who is serving life without the possibility of parole doesn't get gain time, correct?
That's basically true, yes.
And every other sentence that Mr. Tillis was serving, he was entitled to gain time.
He was.
And that is given to inmates as an incentive to get inmates to do well.
Of course.
And that incentive to do well does not exist in cases of life without the possibility of parole.
That's correct.
I want to go through when the defendant had an incentive to be good in jail, the things that he lost gain time from. And you have that sheet in front of you, I think, right here. I just want to make sure that in January of 1995, he disobeyed an order, but he did not lose any gain time. Is that correct?
That's correct.
But June 10th of 1995, the defendant lost 15 days of gain time because he possessed contraband.
That's correct.
February 5th of 1999, the defendant lost 48 days of gain time because he was lying to staff.
That's correct.
February 28th of 2001, he did not lose gain time, but it was still noted that he was disrespectful to officials.
That's correct.
October 25th of 2001, the defendant lost 20 days of gain time because he possessed contraband.
That's correct.
And then February 6th of 2002, the defendant lost 136 days because he was lying to staff.
No, sir. On that first charge of lying to staff, he received 0 days of gain time.
Okay. And then the next one?
The next, there were 2 charges that date, and the second date, they took 136 days gain time.
Right, so I just skipped over the one where he didn't lose any gain time. So the defendant lost 136 days of gain time because he was lying to the staff.
That's correct.
And then there were 4 other disciplinary reports where he did not lose any gain time.
That's correct.
Disobeying orders, fighting, disrespectful to officials, and disorderly conduct.
That's right.
The last one was in December 8th of 2002. Oh, there's 2 more, I'm sorry.
No, it's, the last one was in June 3rd, 2004.
I missed those 2. So there was a June 3rd of 2004, he lost 30 days for disobeying an order.
Yes, sir.
And then August 18th, 2003, he lost 30 days for fighting.
That's correct.
Okay. So I want to be clear that when the defendant would know that his behavior would cause him to be incarcerated longer if he didn't abide by the rules of the jail and the prison. But he knew if he violated the rules that he would be in jail longer.
That's correct.
And he still did it. He still violated the rules.
There are violations, yes, but it's expected.
Right, okay. It's not encouraged, though, right?
Well, certainly not encouraged.
And the reason it's expected is because the population of the Florida State prison system are people that have already shown the inability to comply with the rule of law.
That's correct.
Final question. You indicated, I think you said that Mr. Tillis would have been knowledgeable in car repair. Did I hear you right when you said that?
Yes.
Automotive repair?
Automotive?
So he would have been able to quickly fix a car if there was an easy problem to fix.
I don't know if he could do it easily or not. I just know that he had experience, even as a young man, from his father repairing cars.
Thank you, sir.
Yes, sir.
Any other questions for the witness?
Clear up a couple things. When an inmate is admitted into the Florida Department of Corrections, he comes with a commitment packet, correct?
He comes with what, ma'am?
A commitment packet, information about that inmate.
He does.
And that includes his jail jacket, his disciplinary history in the jail before he got to prison.
It does.
And then occasionally, inmates in prison have to come back to jail for court, and those records are again provided to the Florida Department of Corrections when they receive the inmate back.
All the time.
You need to know who you're supervising in prison.
You do.
Florida eliminated the possibility of parole in the early 90s, correct?
Correct.
So when we say life without the possibility of parole, if an inmate is sentenced to that, he is dying in prison.
He will die in prison.
Mr. Mizrahi's point was, though, on a lesser sentence, a term of years sentence, the Florida Department of Corrections uses incentivized good and gain time. They give inmates time off for good behavior.
That's correct.
At this point, the Florida legislature requires an inmate to serve at least 85% of his sentence for a term of years sentence, correct?
For those not doing life without parole, yes.
Okay, so, because again, life means life in Florida.
Life means life.
And DOC, or Florida Department of Corrections, is trying to incentivize good behavior, and you can take away that good and gain time, like you discussed with the state, correct?
Yes, but there's also the penalty that plays a part in this.
Right, that was the point I was getting to, and so I think the state's point was, well, if somebody's serving life, they have really no incentive to be well-behaved. Would you agree with that?
No,
And why is that?
because if they don't behave, they're going to suffer through disciplinary confinement or close management confinement.
And when we talk about those things, some people know them as solitary confinement.
Solitary confinement.
And they're going to lose the benefit of visitation.
No visitation, no telephone calls, no movies, no tablets. They're stripped of most everything.
And so the Florida Department of Corrections, within its policies and procedures, has the ability to make an inmate's life real unbearable if that inmate doesn't participate or cooperate with DOC's rules.
They do.
I think you would, or did describe Mr. Tillis's disciplinary referral history, and again, we're talking from 1995 to 2004, right?
Yes,
He
ma'am.
had 13 disciplinary referrals,
That's correct.
and I believe your testimony was that those were minor, nonviolent infractions.
They're institutional infractions. They're not laws. They're simple rules that are broken all day, every day by inmates, and officers write disciplinary reports accordingly.
And so I think you called them charges. They're not like criminal charges like we're here in court. It's just,
Infractions.
do inmates get infractions all the time?
All the time.
I mean, have you referred or reviewed someone's disciplinary history and seen hundreds of disciplinary referrals? over
As
the course
many as 300 or 400 for one inmate, yes.
I have nothing further, sir.
Anything else for the witness?
No, yeah.
All right, thank you, sir. You're free to go.
Thank you, Your Honor.
Yes, sir.
Gotta get my stick.
Members of the jury, I think this will be a good time to take our lunch break. Remember the same general procedure as last week. You don't need to stay together, but whether you're together or apart, do not discuss the case. Don't look up anything about it. Don't let anybody discuss it in your presence. And we'll see you back at 1:30. 1:30.